The investigative report of the Senate Intelligence Committee on the CIA's rendition, interrogation and detention practices, also known as the Torture Report, is due to be released after long delay. I'm Safi.
And I'm Stephanie. At Two Views Beyond the Hill, we are talking with Jason Wright, Iraq war veteran and former military defense counsel for Guantanamo Bay detainee Khalid Sheikh Mohammed.
13 years on from 9/11, with the US engaged in fighting in Afghanistan, Pakistan, Yemen, Somalia, and now most recently with the airstrikes in Iraq and Syria, in an ongoing fight against terrorism, this report seems to come at a very important, and some would even say inopportune time. Do you feel that this report is going to be a significant addition to our thinking on the war on terror?
I do think that would be the case. But in the first instance, it's important to talk about what the report actually is. So what we're talking about is the Senate Select Committee on Intelligence report and two other documents associated with it. One is a review by Leon Panetta, the former director of the CIA, who looked at the report, and then also a rebuttal written by the CIA. What happened was the Senate looked at all of the documents in the possession of the CIA, maybe not all, but at least a lot. They looked at 6 million pages of documents to analyze, investigate, and basically figure out what happened after 9/11, when our government started to capture foreign nationals overseas and subject them to certain types of interrogation tactics that have now been properly considered to be in violation of both international and U.S. domestic law. Certain tactics that were waterboarding, that were stress positions, that were sleep deprivation. And there's a whole list of things that were called enhanced interrogation techniques. So the Senate was concerned about this. They have an oversight responsibility over the CIA, and they've undertaken a massive investigation into what exactly happened during these years. As I mentioned, millions of documents, and they've spent considerable amount of money and resources to the tune of $40 million to document what happened.
That's incredible.
But yes, to answer your question though, I think that this report is coming at a very interesting time when it comes to U.S. foreign policy. Just when we've approached over a decade of war post 9/11, with the drawdown in Afghanistan, the removal of American troops in Iraq. Now the U.S. appears to be engaged in another action overseas in both Iraq and Syria. And although the terms war on terror are not being used, but it does appear to be a war on terrorism in many respects that mirrored what had happened before, post 9/11. So it is an interesting time for this debate to happen.
Jason, the information, as you mentioned, contained in the report raises critical questions about government intelligence operations and government oversight post 9/11. And I think also of critical importance, the report raises questions about the lawfulness of the U.S.'s use of enhanced interrogation post 9/11. Can you talk a little bit about the legal implications of the report?
Absolutely. So the report is currently undergoing declassification review. The report and the two other documents, the Panetta review and the rebuttal. I haven't seen the report. I can only tell you what I've read news stories about it and what the president himself has said. President Obama recently said that we tortured some folks, end quote. That's a very powerful statement for the commander-in-chief and the leader of the United States of America to say that, to acknowledge that. We have certain obligations under international law with the Convention Against Torture, where the U.S. has agreed not to torture. Secondly, the U.S. has agreed to investigate and hold persons accountable who may have actually engaged in torture. So the question under international law is, will the U.S. acknowledge its responsibilities and fulfill its obligations? Not just to investigate and document, but to actually hold people accountable for committing torture. The same is true of U.S. domestic law. It's a criminal violation in the United States to torture. It's something that as Americans we've fought for from the dawn of our founding. And if you look at the 8th Amendment of the U.S. Constitution, no cruel or unusual punishment. We fought for that. We fought for that right and we secured it. And we need to honor that right by looking into what we did post 9/11.
Just to be clear about the impacts of these, or what we're talking about. We're talking about techniques that have been designed specifically in order to break down the individual. And this report by Physicians for Human Rights documented very well the impact, and they documented that irreparable and severe psychological and physical damage had been done to these individuals. And we're talking about techniques, am I right, that the US has condemned when used by other states?
That's correct. They have. And in fact, you mentioned waterboarding before. And waterboarding is actually a mock execution. When you take a look at the CIA's OIG report, the one that I just mentioned, the declassified version, you can look at the appendices in that report, and it talks about in excruciating detail how the waterboard actually worked. The point of it was to bring someone to the point of death and back, to the very edge of death. And one man in particular, Mr. Muhammad, as you mentioned, he was subjected to the waterboard 183 times. The US government has previously they prosecuted Japanese war criminals for doing the same to American service members.
And more recently as well, I believe right up until 2006, the US had condemned, I'm not going to mention the states, for use of these types of techniques: waterboarding, prolonged exposure to cold temperatures, denial of clothing and basic hygiene.
Right. And that's absolutely, and I think the point is not whether it's the US or some other country that's doing it. The point is, from the perspective of human dignity and who we are as Americans and the American people, we should reject that, irrespective of what country and irrespective of the purpose. And you mentioned before the Physician for Human Rights report. It's an excellent report. I'm aware of the report. When you take a look at the design of the detention and rendition program, you'll find, again, in the CIA's OIG report, that the purpose of the interrogation was to psychologically dislocate the individual. A recent report, a very famous document written by a number of experts and physicians and mental health counselors in the field of torture, a document called the Istanbul Protocol. 75 experts in the field have said that the purpose of torture is to psychologically disintegrate. So on the one hand, the US government policy was to psychologically dislocate. On the other hand, you have experts around the world say the purpose of torture is to disintegrate the person. So really what it does is it changes the person fundamentally, not just physically in terms of the physical effects of torture, but mentally as well. You no longer have the same person.
I'd like to turn to that and talk about the efficacy of the information that is elicited during enhanced interrogation, and whether or not you think the release of the report will affect the current ongoing military commissions in Guantanamo Bay.
I think the military commissions will be impacted, and what you have to date is you have about 8 prosecutions before a military commission, the current iteration down in Guantanamo Bay. We can talk another time about those cases, but right now there are 2 death penalty trials that are ongoing. One against 5 individuals charged with complicity in the 9/11 attacks, and one against an individual who was charged with complicity in the USS Cole bombing. The Military Commissions Act of 2009, which is the predicate statute, if you will, the criminal code that applies for Guantanamo Bay commissions, is predicated on a regime of secrecy, ultimately. It's to ensure, and this is not unusual for federal court for there to be national security cases, but the goal is to ensure that information about the CIA's rendition, detention, and interrogation program, that does not make it into the public view. So there are very restrictive rules of evidence and restrictive rules of procedure that limit the defense counsel's ability to pursue investigative leads in that regard, to present evidence before the court, at least in a public hearing, and also to share that information with the client. There's a rule that says that anything that's classified can't be shared with the actual defendant. Now, someone who's on trial for their life and they can't see the evidence against them, that's a serious due process violation that I can tell you the U.S. would not stand if that were being applied to an American citizen facing trial overseas for their life. So I think that there's an intellectual or philosophical underpinning with the military commissions to protect some of this information. If this information is now going to be released, who knows where it could lead.
So you represented Khalid Sheikh Mohammed, your client, for 3 years, building a defense for him. We're talking about somebody who's actually one of the most well-known high-value detainees, somebody that allegedly played a key role in 9/11, someone who's responsible potentially for the deaths of 2,976 civilians. And you've come under some criticism for helping to build his defense. Can you tell us what you feel you were doing in that process?
Well, I was appointed by the Office of the Chief Defense Counsel for the Department of Defense to be a military public defender for Guantanamo Bay detainees. And so not only did I represent Mr. Mohammed in connection with the capital case currently against him, but I also represented an Afghan villager by the name of Obaidullah. But as a military public defender, I did the same thing that public defenders do across the country, whether they're in state court or in federal court, which is to not necessarily represent the client, but also to represent what our Constitution stands for, which is that everyone is entitled to have a lawyer. Everyone's entitled to have a fair defense. And everyone is entitled to have that day in court. And so certainly what I've seen with respect to Obaidullah is that he has not had a day in court yet. But that's why I was there. I was there to ensure that when he went to court, he would have a lawyer there to help him. And Mr. Mohammed, that's the same as well, is to ensure that his right to counsel, a right that this country has been founded on and predicated on, these civil liberties that are enshrined in our Constitution, that they be given full meaning and effect. And really, it's a reflection of who we are as Americans more than anything else.
So in building his defense, you were effectively defending the values that the US stands behind. And yet this report is going to acknowledge, as President Obama did a few days ago in front of the UN, that the US has certain shortcomings when it comes to acting in concert with our stated values. For those who think that the report is going to do more harm than good, do you agree with that view? And what do you hope that the Panetta Review and the release of this report is going to be able to achieve?
You mentioned at the outset that this could possibly fuel a public debate. And that's what I really hope it will do. We've had a very proud history of building this concept of the rule of law. But at the same time, we've had some dark periods. We've all read about the treatment of the Native Americans when we first arrived. We know about our history of slavery. We know about the denial of the right for women to vote. We do have conversations in the United States about things that we've done wrong. And those conversations only make us stronger, they only make us better. So bringing light to that dark period of torture, of what the American government did post 9/11, can only make us better as a country, it can only make us stronger as a country, it can only make us safer as a country.
But is debate enough? You mentioned the civil rights movement, you mentioned women's suffrage. Those all resulted in actions, women's ability to vote, blacks and whites being able to go to school together. If it's only debate that results in response to this report, are we getting anywhere? Is it enough?
There is an extraordinary opportunity here for rediscovery and also some redemption for our policymakers, for our leaders to condone it and to take appropriate actions to convince the world that this is not who America is, that America is better than this. And I think the time is now.
The argument, of course, is that the use of these techniques was really important or was really required in order to extract information that could be used as evidence for the trials and also as information for the continuing fight against terrorism.
Mm-hmm.
Now, not even touching upon the issue of the efficacy of the information or the usefulness, do we feel that we're in a place where we are safer we live in a safer world, that national security interests and the interests of the safety of individual Americans in the US and abroad is less at risk than it was at the time of the attacks on the World Trade Center?
There are many layers to that question, and in the first instance, I think I understand that most Americans don't feel that they're safer today than they were 10 years ago, 20 years ago, or 30 years ago. There are images of brutal attacks occurring on television, in the news, and the like. But I know historically this is the safest period that the United States government has had ever since its infancy. We're living in the safest time ever. And the question of perception is very important. The National Counterterrorism Center, a government agency, in 2011 produced a very good report on this question of how safe are we from terrorist attacks in the United States. And there is a myth, I think, that's out there, that we are subjected to the possibility of a terrorist attack at any given time. When we're driving to the mall, or we're getting on the subway, or we're dropping our kids off at school. And it's a myth, unfortunately. That myth has been perpetuated, and people are living in this state of fear. The chance of being harmed by a terrorist attack as a U.S. citizen is 1 in 20 million. The chance of being struck by lightning is 1 out of 126,000.
So more likely.
We're more likely to be struck by lightning than by a terrorist attack. Now that doesn't somehow, I don't mean to suggest this lightly. It's awful and it's terrible when people are victims of a terrorist attack. But I think it's okay for people to feel safe. And to feel safe is to know that you're safe. And perhaps this could be something that could fuel part of that debate, where in this country we would not be okay with having an erosion of our civil liberties in exchange for that strict national security posture, if you will. And you know the quote from Ben Franklin, of course, that a country that will sacrifice its, and this is a terrible paraphrase, but a country that will sacrifice its civil liberties for national security deserves neither.
Jason, thank you very much for joining us here.
Thank you for having me.
It's been a real pleasure. Thanks.
Thank you.